See, there are three types of doctrines which are very important for the exam. Number one, doctrine of constructive notice, doctrine of indoor management, doctrine of ultra vires. Doctrine of ultra vires. Let us first understand what are all the doctrines in detail within span of less than 5 minutes. Number one, doctrine of constructive notice. Doctrine of constructive notice says like this. So doctrine of constructive notice says this way. As per section 399, there is a section called as section 399. Any person may inspect by electronic means any document kept with ROC. Any document kept with ROC. So as per section 399, any person may inspect by electronic means any document kept with ROC. Any person can take, see, as per section 399, any person may be a member, may not be a member. Any person, outsider also, may inspect by electronic means you need not come to company. Electronic mode you can inspect any document kept with ROC. Any document kept with ROC means prepared by company, filed with ROC. Any person can inspect. Okay, next. Any person not only just inspect, can take a copy and extract of any document kept and registered with ROC. If it is a registered document kept with ROC, okay, anyone can not only just inspect but can also take copy. Pay money, take the copy. Therefore, nothing is a private document. Everything is available public. Any person can also inspect. See, what we said, any document. What we said, any document. First one word, any person can inspect any document kept with ROC. Any person can take copy or extract of any document kept with ROC. Any document, what document also will come? Memorandum and articles also will come. So therefore, any person can also inspect MOA and AOA, since they are also which document? Public document. They are also which document? Public document. Okay. Since MOA and AOA are public document, every person dealing with the company is presumed to have the knowledge of contents of MOA and AOA and understand the contents in a right sense. Means not only just reading the memorandum, you should also understand in a right sense. Whether you really understand or not, company will not bother. Company will presume that you understood the contents in a right sense. You understood the contents in a right sense. That is presumption. Okay. Presumption means what? Assumption. Whose assumption? Company's assumption. Against whom? Outsiders. Against whom? Outsiders. So, whether you really read memorandum or articles, I don't know. I will tell only 3 points. Every person can inspect any document kept in electronic means. Any person can take a copy and extract of a document kept in electronic means with ROC. In that any document MOA, AOA will come. So you can happily take and read. So I will presume that every person dealing with the company have complete knowledge of MOA, AOA, understood it in a right perspective. Then only you enter into contract is my assumption. Company's assumption. Therefore, even if you do not read, I don't care. Okay. Anything happens at a later stage, company is not responsible. Outsider has to suffer. Therefore, doctrine of constructive notice works in favor of company against to the outsider. Up to here, understood or not, everyone? Doctrine of indoor management. Doctrine of indoor management. Exactly reverse to constructive notice. Constructive notice, what is the presumption? The presumption of constructive notice is company will be protected against the outsiders. Okay. When if you don't read memorandum articles, I read memorandum, I read articles, I understood in a right sense. Now, if company do not comply with what is there in MOA and AOA, outsider can sue the company now. So this is a doctrine which protects the outsiders against the company. That's called as the doctrine of indoor management. In simple language, how to write an exam? See, in case of doctrine of constructive notice, company will not inquire outsider. Company will not inquire outsider whether he read the memorandum articles and understood in a right sense. In the same way, if you comply with memorandum articles, okay, outsider need not inquire company whether resolutions are properly passed or not. As far as internal regulations are concerned, as far as indoor management of the company is concerned, I will presume, outsider will presume that everything has been done as per memorandum and articles. Memorandum articles, the special resolution is required. I will not inquire whether you passed or not. I will presume that it has been passed. I will presume that it has been passed. Everyone understood what is indoor management clearly? Yeah. Okay, let's read. Read this particular point. As per doctrine of indoor management, outsider means person dealing with the company need not inquire about internal affairs. Need not, because constructive note, you did not inquire me whether I read or not. Indoor management, I will not inquire you whether you have done or not. As far as internal affairs of the company are concerned, outsider may presume that company has followed all the formalities and doctrine of indoor management acts in favor of outsiders against the company. Everybody up to here understood? Doctrine of ultravires. Doctrine of ultravires is the third doctrine. Okay. According to this doctrine, what is the main subject matter? The term ultra means beyond, and the term vires means powers, and hence ultra vires means beyond the powers. Ultra vires means beyond the powers. Listen carefully. I will give you a good example for this. See, when I say beyond the powers, there are doubts. Sir, beyond the powers is an incomplete statement. Beyond the powers of what? There can be popularly following cases. Beyond the powers of act, beyond the powers of MOA objects clause, beyond the powers of AOA, beyond the powers of board of directors, beyond the powers of board of directors. Anything they can ask in exam. Okay. So what is the basic rule behind ultra vires? Ultra vires means company cannot employ the funds for any purpose other than mentioned in objects clause. Company cannot do any act other than what is said in the objects clause. So you cannot depart from the objects clause of memorandum unless and until you alter it. Is the subject matter of discussion in the objects clause concept and ultra vires concept. Okay. Now let's come to this particular discussion. Once this is understood, there can never be a question that comes in examination to trouble you in this regard. Okay. Listen to my discussion properly. Beyond the powers means ultra vires the act. You have went beyond the act itself. Companies Act like clearly said you can carry on only legal activity. You are doing illegal activity. I said you should have minimum 7 members in public. You are doing the business only with 5 members. Like this, you have went beyond Companies Act and doing things. Or second one, our object is furniture manufacturing. Okay, you are doing manufacturing of iron and steel, or you are doing the manufacturing of cement. Objects of furniture is there. Doing the cement business, you are going beyond the objects clause. Okay. So whenever you are going beyond memorandum, you are doing what company is not allowed to do. You means whom? Directors. Company is artificial person. It cannot do anything on its own. Who will do on behalf of company? Directors. Means the board of directors are doing such acts which are beyond the powers of company itself. So company A able to do only furniture manufacturing. You are doing cement. Therefore, if you are going beyond the act, if you are going beyond the memorandum, your transaction will become void ab initio. Second, it will become illegal. It will become illegal. Next, not ratifiable. Ratifiable means excuse cannot be given to this. Company not binded means company will not become liable, because when company will be liable for the acts of directors, if directors does such things which are in the objects clause of memorandum, but it is a mistake. For the mistake of the agent, principal will suffer. But you have done what I cannot do. See, if agent does something which principal can do, but it done in a wrong way, principal will become liable. But agent, if he do something which principal also cannot do, agent become personally liable. Here the agents are board of directors. So transaction becomes void ab initio, illegal, not ratifiable. Company will not be binding. Board of directors will become personally liable. Personally liable. Next, I have done ultra vires say, but not ultra vires MOA, ultra vires act. I am doing what memorandum said, but I am not doing as per AOA. I am doing as per AOA, but I am going beyond board powers. Beyond board powers. These two are called as ultra wise the AOA or board of directors powers, but intra wise the memorandum and act. Sir, give one example, sir. If in exam, we should not get confused. Company memorandum la borrowing powers are given. Borrowing powers are given in company memorandum. Okay. In the articles of association, they have clearly written that up to 1 crore, board of directors can themselves borrow. Okay. Means they need not go to anyone. Up to 1 crore aggregate, they can only do. Beyond 1 crore, okay, beyond 1 crore, board of directors only will borrow, but with the prior approval of shareholders. Okay, but they did not take shareholders approval. Now, borrowing is valid. It is as per objects only. Clear? Board only borrowed. It is also as per articles. But board is allowed to borrow only to what extent? 1 crore. They borrowed 3 crores without permission of shareholders. Act done is valid. The way in which they have done is not valid. Now, this will not become void ab initio. This will become voidable at the option of the shareholders. This will not become illegal. This will become irregular. This will not become non-ratifiable. This will be ratifiable. What is missing? Shareholders' approval is missing. Why? Emergency like could not take their permission. Now you take. Means generally you should take and borrow. Now you can't do anything. You already borrowed now. Go to them. Ask them to ratify. Tell the problem. Shareholders, if they ratify, voidable will get converted into valid. Shareholder said that, "Arey, idiot, why you borrowed without our permission? We are not going to approve," means voidable will get converted into void. Okay. So it is voidable. Whether to turn into valid or void depends on the ratification. Next one. If ratified, company liable. Not ratified, board of directors liable. Okay, that's it. This is the end of ultra-wise discussion. So you have to present the answer this way. What is doctrine of ultra-wise? You have to write. Next, you cannot go beyond, you cannot depart from the objects clause and does anything, because normally you have to do what is there in objects clause. You are not permitted to depart from that. But in one case you can go beyond. When alter and go. Alter the objects clause, increase the scope of your objects, and then do. Next, company can be restrained, means company will be stopped from employing its fund for the purposes other than those mentioned in the memorandum. It cannot put money in a place other than what is said in memorandum. It cannot carry on any trade which is different from that of the things specified in the memorandum. Okay. Now let us discuss on one important segment. Listen. There is a company. X Limited. There is an outsider called as Mr. X. Mr. Company approached Mr. X. Company means board of directors. Approached Mr. X. This company is in furniture. This person is in supply of cement. Okay. Or this person is in the supply of, for example, clinkers. Clinkers will be used to make cement. This fellow is supplier of cement. X Limited approached X. X, I want 100 tons of clinkers. Okay. X, without any stretch of imagination, supplied the clinkers. X Limited did not pay the money to this. Credit transaction did not pay. Can X make a case against X Limited and recollect the money from X Limited? Answer is absolutely no. Because my object is furniture. X Limited directors entered into contract with you for cement. It is not within the objects. You directors and collect from them. Company will not become liable. Then X will tell, how will I know what is your object? Your director said clinkers I supply. How would I know whether it is your business or not? Read memorandum. How will I read memorandum? It is prepared by your company, kept within your company. Then we will tell, arey fool, memorandum is not a private document, it's a public document. We assume that you already read and entered into contract. This is a void contract, illegal contract. You cannot sue the company. If you wanted to sue, go out of Companies Act, file a cheating case against the directors under the Civil Procedure Code and collect your money. But under Companies Act, it is a void ab initio. Illegal, non-ratifiable, company not liable, directors are personally liable, go and file a case against them. Hopefully everyone understood how to write the answer clearly. Now see this point, it will be meaningful for you. The impact of doctrine of ultra vires is that company can be neither be sued nor it can sue on it. Since memorandum is a public document, it is open to the public inspection. Therefore, when one deals with the company, one is deemed to know about the powers of company. Okay, if in spite of this, you enter into transaction which is ultra vires, you cannot enforce it against the company. Okay, up to here at least you need to write here. Because question will come for 6 marks. 2, 3, 4, 5, 6. That's it. Up to here you need to write an exam. If ultra vires question comes in examination. Clear? With this, doctrine of constructive notice, indoor management, ultra vires completed. Now I will discuss one more concept and close this. See here. Next concept is exceptions to doctrine of indoor management. Exceptions to doctrine of indoor management. There are 3 very, very important exceptions to doctrine of indoor management. Number 1, knowledge of irregularity. Knowledge of irregularity. Suspicion or negligence. Third one, forgery. Listen. Knowledge of irregularity, suspicion or negligence, forgery cases. Knowledge of irregularity means what? See, company has taken loan. I will be very, very fast in dealing with this concept. Please listen carefully. Company has obtained loan from director. 3 crore rupee. Same example. 3 crore rupee. From whom it has obtained? Director. Okay. Director is also an outsider now. Insider means coming in, not like that. Insider, anyone other than company is an outsider. Sorry, okay. Listen now. Director has taken loan. Director has given loan to company. Company has taken loan 3 crore. Actually 1 crore beyond, company can borrow only with the shareholders' permission. But without shareholders' permission, this director has given loan. He read the memorandum, he read the articles, understood it in the right sense. Over. Everything he has done. But company did not pass a resolution. Shareholders' approval they did not take. Now what will happen? Normally, this will become a enforceable contract only. This will become enforceable contract because money came into the hands of company legally or not. Yes, that's all. So even though internally you did not pass a resolution, outsider will not get affected. That is normally. But we are reading exception. Who you are in this example? I am a director. As a director, you will definitely know whether in your company resolution is passed or not. Yes. Therefore, indoor management will not protect you. That's what we are going to discuss here. See. Exceptions to indoor management. Concept. The rule does not protect a person dealing with the company who has actual or constructive knowledge of irregularity. Means if you already have the knowledge of irregularity, this will not protect you. Okay. I am projecting the case law. Whenever you need, you can read. Next, suspicion of irregularity or negligence. Okay. See. It's very simple concept. See here. Listen. Company can do something. Who can do on behalf of company? Directors have to do on behalf of company. Watchman can do on behalf of company. A normal staff will do on behalf of company. Company has to do something means directors have to do on behalf of company. Okay. In a particular situation where accountant borrowed money from an outsider. Outsider read memorandum. Outsider read articles. Outsider understood in a right sense. Borrowing is made by accountant. He gave money to him. Accountant took the money, ran away. Can company become liable now in this case? No, because basic suspicion you should get. You are negligent fellow. For you, indoor management protection is not available. Means when the facts of the case are in such a way. Listen, when the facts of the case are in such a way which invite a suspicion, means you should get a doubt. Na? How accountant will have a power to borrow 5-6 crores on behalf of company? And tomorrow, some person on road will come to you and tell, sir, see, memorandum is a public document for you, also for me, for anyone. 140 crore population of India, memorandum is a public document. If public document is available to you, public document is available also to me. Na? Now I will take a printout of memorandum of TCS, TCS memorandum, TCS articles I will take. I will come to you and tell, sir, I'm not an accountant. I'm an accountant of TCS, or I'm a director of TCS. Please give money. You will give money. Yeah? For that you will company TCS will pay to you. No, you should have a basic level of common sense. Here you are negligent. And whoever tell the name of company, for them you will give money. Like that only this will be. So suspicion or irregularity means when the facts of the case are in such a way which invites a suspicion, then you should clear that suspicion, inquire, check whether really he is an accountant, check whether that accountant is having a power or not, then give the loan, company will become liable. Okay, next, last case, forgery. Very, very important expected question for this September exam. What is this? Forgery whenever happens, what happened? Forgery means signing others' signature. Signing others' signature is called as a forgery. As it is, copying other signature is a forgery. See, there is a shareholder A. There is a person B. There is a outsider C. B, C are outsider. A is a shareholder of a company. Listening up. B stolen A's share certificate. Okay. A's share certificate. Who stolen? B stolen. Transferred it to C. C is a innocent buyer. Nothing he know. Without knowing anything, he paid to B. He paid to B. B took the money and share certificates of A are transferred to C. Now who is the owner? C became the owner. After 1 month, A came to know that he don't have shares. Immediately made a police complaint, FIR filed, and finally came to know that there is a forgery that happened. Forgery means no consent. No consent means no contract. No contract means B don't get any right on the share certificate. When you don't have a right, as per Sale of Goods Act, you cannot pass a better title to C. C also cannot become owner. Now, indoor management will not protect C. Very sad. Indoor management don't protect C. Means C should not tell, sir, I read memorandum, I read articles, I understood in the right sense. I don't know, I have no knowledge of irregularity, that there is a theft by B. He transferred, I purchased, that's all. Even then law says, I am very, very sorry. B has a transferred shares, goods. Sale of Goods Act, a share is a good. B transferred goods to you. On that goods, B don't have ownership. When B don't have ownership, how come he will transfer ownership to others? On what he don't have an ownership? Nemo quad that non-habit. When I myself don't have a right to transfer on the goods, how can I pass that ownership to you? So when ownership of B is void, ownership of C also become void. Forgery cases la indoor management will not protect outsiders. Forgery case nothing. Now you will tell, sir, then unnecessarily C will suffer na? No, not that way. Indoor management will not protect you. But you can file a criminal complaint against B and get back your money. Understood the point or not? We can get back money, but not under Companies Act. Indoor management will not protect you. Understood the point clearly, everyone? So these are the three cases. So when there is a knowledge of irregularity, when there is a suspicion or negligence, when there is a forgery, indoor management will not protect you. This case law happened in forgery. Reuben versus Great Fingal Consolidated. In that case law, this happened. Everybody completed fully all the doctrines and examples as well.